Good afternoon. Delighted to be joined by Septimus Knox of SRM. He is a director of the firm and deputy head of disputes there. So thank you very much for joining us, Septimus.
Thank you very much for having me, Ollie. It's a pleasure to be here.
So you obviously do quite a lot of work in the sovereign dispute space. So it would be great to sound you out on a few things and just learn a bit more about the practice at SRM and the kind of trends you've seen in the sector. So yeah, what are the recent kind of patterns you've been witnessing in the sovereign dispute space?
We work on sovereign disputes. We work on routine commercial litigation, arbitration, all manner of different things. But I think in the past few years, we've definitely seen more in the sovereign space. That can be working against states, it can be working for states, it can be working enforcing awards against state-owned entities. It's very broad. But I think a couple of things. I think the consensus is it's getting harder to enforce awards, judgments against sovereigns. And in terms of trends, I can start with the obvious answer, and that is claims against Russia or claims against Russian SOEs arising from Russian acts of state, such as the full-scale invasion of Ukraine a couple of years ago. These are, under this umbrella, there's a huge amount of different things. Yes, directly conflict-related claims, expropriation claims, counter-sanctions claims, and then, of course, arbitration over contracts that were cancelled or otherwise terminated as a result of the invasion. Some of these were actually launched by Russia and its SOEs. Outside of the obvious, I think the other development that we're keeping a very close eye on is the rise of investor state claims as a result of changes to environmental policy worldwide. And there's a couple of things there. There's some states are trying to go net zero, and that means that they're phasing out things like coal, cancelling concessions, which creates disputes. In other parts of the world, particular minerals such as rare earth metals are becoming highly sought after assets, and some countries in Latin America and sub-Saharan Africa are seeking to reassert their control over those assets, shall we say. An example of that would be in Mexico, and this obviously Mexico's lithium, to be specific, and that obviously gives rise to a huge number of investor state claims. Finally, if I was to spot another trend, it would be related to the types of claims that we see. This is more of a legal point than an investigative point, but there are more and more arbitrations under free trade agreements and regional trade agreements rather than under bilateral investment treaties. So, for example, I think there was the first investor state case filed against the EU itself about a year ago or sometime last year.
Thanks very much. Really interesting, and definitely matches the kind of trends we've been seeing at Deminor. Certainly some requests coming from, or focusing on, I should say, Latin America and sub-Saharan Africa. But very interesting, thanks. I mean, and so in terms of actually helping your clients, trying to enforce awards against sovereigns and their assets, what are the obstacles that you typically come across when doing that research?
Yeah, again, I'll try and stay in my lane here as an investigator rather than veer into the legalistic, which I did at the end of my previous comment. But I mean, in terms of the obstacles when we're tracing assets themselves, and identifying potentially attachable assets that can ultimately, you're a funder, you're looking for monetization at the end of the day. There's obviously two very obvious dynamics that are unique to sovereign investigations. That's sovereign immunity and alter ego. On the sovereign immunity point, the burdens of proof regarding commercial use of a given asset can be high, and for example, if you identify a high value property, you need to make a strong case that it's being let out on commercial terms, and there's a commercial exemption there. And on the alter ego point, it just varies. It's a high bar to clear, and it varies massively from jurisdiction to jurisdiction. So we have to be cognizant of that. Another dynamic, I mean, again, it's a fairly obvious one, but it's worth pointing out. Many of these assets that we look for that belong to states are mobile, so vessels and planes. And obviously, when something moves, it's harder to find, and ultimately harder to seize. So those are three, I should say, fairly obvious points. A fourth point, perhaps, is that states have unique tools available to them when they want to frustrate enforcement proceedings, and states that have decided not to honour an arbitral award, shall we say, have usually done it before. They've usually learnt from previous enforcement efforts against them, and they've structured their assets accordingly, which makes our job harder. For example, a recalcitrant state debtor might seek to extend diplomatic immunity to commercial properties. They can also use the full apparatus of the state to frustrate and stymie investigative efforts. By that I mean, if you look at the UCOS case, Russia made information about its assets abroad a state secret, which obviously makes intelligence gathering harder. A related point there is, a crucial arrow in any investigator's quiver is human intelligence. And that's human, information derived from people. And typically speaking, when a matter's commercial, there's less fear or concern when you're talking to people about it. But when a state is involved, especially states that are, maybe not NATO aligned, shall we say, or states that are particularly recalcitrant, that there is a high level of fear and concern among people on the ground, and people we need to get to and speak to. And we have to be very cognizant of that. They're very afraid of retribution, of what might happen to them. So those are some of the obstacles that we come across.
Thanks again, Septimus. Yeah, really, really interesting take on your experience. Just to shift the attention of focus away from sovereign disputes for a second, what's been your experience of working with funders, perhaps both on a personal level and at SRM more broadly, and the requests that you typically receive? Are they quite similar or very different? Does it depend on the funder? What's your kind of experience there?
Just generally speaking, I think, and I'm not just saying this because I'm on a funders podcast, I think the funding market and its rise has been a real boon for investigators, and it's really sort of helped bring the work that we do into the mainstream and make it a lot more. It's been a force for good ultimately. We focus on the pot of gold, on the assets the assets at the end of the legal proceedings, which is very aligned in my mind to what funders are looking for. You're looking to ultimately give a positive return to your investors. So recoverability, actual assets are crucial to both our processes, and they're really at the core of it. It's that, how do you turn a legal judgment or a legal award into cash? In terms of how we work with funders, it's very broad. But again, I think funders being present in the market means that questions of whether to pursue a claim, how to pursue it, and how to do so, importantly, I think, in a cost-conscious manner, are much more common. So we, there's a very broad range of scenarios. I'll touch on a few. So we work with banks and funders to assess NPL portfolios. Sometimes we're assisting on triaging these portfolios. Sometimes we're helping a bank find a funder. We're tracing assets in those scenarios. Sometimes we are helping a claimant achieve funding by preparing their claim for a funding decision. So that's focusing on the recoverability side of things and making sure that the claim is viable from not just a legal perspective, but from a financial perspective. Is there going to be a return at the end? Another thing we see a lot when working with funders is being asked very specific questions sometimes. So, recovery can hinge on a very specific piece of non-public information, such as who is the beneficial of this asset, which is held by an SPV or an offshore entity. And that's something we come across a lot. In very rare cases, we have actually worked with funders when an individual has reneged on their funding agreement. So sort of helping the funder recover funds, which is an interesting dynamic. But, every funder has a different approach. They all have slightly different requirements. But I think at the heart of it, when we work with a funder, we're laser focused on, or a funder is involved in a case, recoverability becomes crucial. It remains very high on the list of priorities. And I think the other thing that's crucial that we have to consider, I think we consider it in all cases, but is the question of proportionality. Are our efforts commensurate with the outcome that we're seeking to achieve? Because that can be very important. There's no point spending huge amounts of money when the return is going to be is not going to match those efforts.
Excellent, thank you. Finally, it would be remiss of me to conduct this podcast without any mention of AI, which has obviously been the buzzword of 2024, and I'm sure we're at the beginning of things, it seems. So a long way to go. How do you think the development of artificial intelligence is going to impact asset tracing and investigations generally? And latterly, have you already seen benefits in your work? Are our jobs safe?
So I think our jobs are safe for the time being. And I might answer your question in reverse. Have we already seen the benefits? Yes, I think we have. And I can give you a couple of examples. So, 10 years ago, if you located a photo of an individual, you might then spend, everyone might crowd around a computer trying to compare it to another photo and say, is this the same person? Nowadays, we use facial recognition software and we find dozens or hundreds of photos of an individual online in an instant. Another example would be machine translation, which again is a type of AI. So that's, you get a PDF in a language that no one speaks or that is very rare. You can translate it into English in a matter of seconds. That is, again, something that used to require a lot of effort or potentially cost outlay, professional translation, something like that. Another example of how AI has changed an investigator's job is enterprise search. So, all investigators in our world have collected huge amounts of data and information over the times in which they've existed, and these used to be held in complex file systems, whereas now, almost everyone has an AI-backed way of searching through all this information and bringing up pertinent information in seconds. Those are just a handful of examples. On the flip side, I guess there's the malign actors of the world, the fraudsters, the hackers, whoever it might be. Also, you can use AI, and they can use it to make our jobs a lot harder. They can create deep fakes. They can pump out compromat or fake news on an industrial scale. That they can use it to they can use large language models to create convincing emails in a language they don't speak and send them out. So while AI sort of tooled us up, it's also tooled up our adversaries in some cases. But I suspect, as you said, AI is the flavor of the month, but I think it's the flavor of the month is generative AI and OpenAI's ChatGPT in particular. And I suspect that's what we're really driving at here. The issue with a large language model is that it requires the transfer of data to a third party. That makes it a much wilder horse to control. And there are lots of issues there, relating to data privacy. For example, we handle our clients' most sensitive data. We're answering complex business critical problems. And I can't imagine they'd be very happy if they found out we were uploading that all into ChatGPT and Sam Altman and his friends were using it to train their next GPT-5 or whatever it might be. So, and we use it for certain things. You can summarize an article or translate an article in a large language model very easily, but it's not spitting out investigations, and it won't be anytime soon. So are our jobs safe? I think yes. And I think they'll be safe for some time. I think what AI has done and will continue to do is changed our methodology, but it's typically by augmenting it and making a more analog process, or a process that used to be analog, more efficient, more effective, and easier.
Excellent. I couldn't agree with you more. I've definitely found it's certainly made a number of processes more efficient. And I think in terms of saving time for smaller administrative tasks here and there, it can be a real help. But as you say, the data we're dealing with is often very sensitive, and we have to be very careful when handling it. So yeah, great to get your view on that. And that concludes the podcast. And yeah, Septimus, just want to say a big thank you for taking the time to join us today. It's really interesting to get your views on sovereign disputes, funding and the requests you get, and AI and how it's impacting our kind of work. So appreciate you taking the time, and I hope we can catch up again soon.
Ollie, thank you very much for having me. It's been a pleasure.